Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-decision episode of SCOTUScast. I'm your host, Spencer Karen. On February 22nd, 2021, by a 6-3 vote, the Supreme Court denied cert in Repubulican Party of Pennsylvania versus Degraffenreid. There were two questions presented, which the court decided not to entertain. The first was whether the Pennsylvania Supreme Court usurped the Pennsylvania General Assembly's plenary authority to direct the manner for appointing electors for president and vice president under Article 2 of the Constitution, as well as the Assembly's broad power to prescribe the times, place, and manner for congressional elections under Article 1, when the court issued a ruling requiring the state to count absentee ballots that arrive up to 3 days after the election day, as long as they were not clearly postmarked after the election day. The second question in this case was whether the decision is preempted by federal statutes that establish a uniform nationwide federal election day. The three justices who dissented in the decision to deny cert were Justices Thomas, Gorsuch, and Alito. All three acknowledged that the hearing of this case would not alter the outcome of the 2020 presidential election, but would be important nonetheless in the event that similar issues occurred in upcoming elections. Derek Muller, professor of law at University of Iowa's College of Law, joins us today to discuss this cert denial and the three justices' dissents.
There were many expectations about whether or not the Supreme Court was going to weigh in on the 2020 presidential election at some point, and every opportunity it had to do so ahead of the election ended with something of a whimper, occasionally weighing in, but largely preserving the status quo and holding off on some of the bigger questions until after the election. And a couple of cases out of Pennsylvania promised the opportunity for the Supreme Court to weigh in on maybe some of the more salient questions arising in election law today, but the Supreme Court decided not to take these cases. In Repubulican Party of Pennsylvania versus Degraffenreid, and a related case called Corman versus Pennsylvania Democratic Party, only three justices indicated that they were willing or interested in taking the case, and since it takes four to grant a writ of certiorari, the Supreme Court declined to hear these cases. They came out of the 2020 presidential election as Pennsylvania had, as many states do, some limitations and restrictions on when ballots can be received in order for them to be counted. The Pennsylvania legislature had a clear rule saying that ballots had to be received by election day. But the Pennsylvania Supreme Court, in a state law case, looked at that law that the legislature had enacted and determined that Pennsylvania's Constitution, which included a clause known as the Free and Fair Elections Clause, coupled with other concerns arising out of the COVID pandemic, meant that the Pennsylvania Supreme Court extended the deadline for ballots to be received in the election from Election Day to 3 days after Election Day. Some states do this by statute, but the Pennsylvania Supreme Court had done so by interpreting the state constitution. And so as this case bubbled up before the Supreme Court ahead of the election, the Supreme Court declined to take the case, declined to stay the enforcement of that judgment, but did say that the Pennsylvania legislature, or the Pennsylvania Secretary of State, should set aside the ballots that would otherwise have been counted as having received in those 3 days after the election, set those aside and segregate them in the event there was some controversy that arose over them. So that created some anticipation about what if Pennsylvania was so close, and who knows how these ballots came out, about whether or not the Supreme Court's decision to sort of segregate these ballots would ultimately be decisive. But as Pennsylvania was a fairly significant victory for Joe Biden, followed by a margin of victory that far exceeded the 10,000 votes in dispute that arrived after Election Day, that point ended up being something somewhat moot. So after Election Day, the question was, well, maybe we could address this question, this particular legal question at issue being whether or not the Pennsylvania Supreme Court, in interpreting the Pennsylvania Constitution, usurped the state legislature's role. Because under the Constitution, it is the legislature, that specific term, that is given the power to dictate the manner of presidential elections and congressional elections. And for the last 20 years or so, particularly after Chief Justice Rehnquist's opinion, concurring opinion, albeit, in Bush versus Gore, indicating that certain interpretations of the state Supreme Court can so fundamentally undermine the state legislative scheme to rework it in such a way as to undermine the legislative intent. The question arose here as not just a matter of statutory interpretation, but a matter of state constitutional law, whether the Pennsylvania Supreme Court could, interpreting constitutional law, effectively constrain the state legislature's decisions. This is an abiding question that could have far-ranging consequences in the future if state courts and state constitutions are limited in how they decide rules pertaining to federal elections once the state legislature has been clear, or at least as clear as it can be, about some of these measures. So given that the election was over, I think there was some thoughts that maybe the Supreme Court would, with maybe cooler passions and recognizing that this case would not be decisive in the outcome of any election, take the case. It was in one sense moot because it wasn't going to change the outcome of the election, but there is an exception known as capable of repetition yet evading review, where oftentimes in election law cases in particular, there's a sense that these disputes will recur, they will arise again. And in election law disputes, it is difficult in the compressed time frame to adjudicate them. And so I think there were a couple of opinions that came out. Justice Thomas wrote one opinion dissenting from the court's decision not to hear these cases, really emphasizing that there were extensive reasons for the court to weigh in while there were cooler passions, and that the case was, well, in one sense moot, likely to recur. But he also emphasized that there were allegations of fraud, while at times noting that we have not seen actual fraud, but emphasizing that we want to ensure voter confidence by adjudicating these issues when there's the time to do so. Justice Alito also wrote separately, joined by Justice Gorsuch, but really emphasizing the mootness point to say, look, I think that these issues are likely to recur. State courts are likely to interpret state constitutional provisions and come back again. We think that there are concerns about the pandemic that are going to continue to linger as the next elections are coming up shortly. And we think that public health officials are going to provide certain kinds of guidance even going forward that might dictate and change the rules for how voting works. And so there were at least 3 justices on the court who were interested in adjudicating this case ahead of something like 2022 or 2024. But clearly 6 members of the court at least thought, for a variety of reasons, perhaps mootness, perhaps the merits, they shouldn't take the case. And so it does leave, I think, lingering questions about what is the appropriate role of state legislatures in regulating federal elections. At what point do state court decisions so rework the legislative scheme as to undermine that federal constitutional guarantee that is the legislature that dictates the results. But mootness makes this an easy one for a majority of the court, or a supermajority in this case, to kick down the road for a little bit longer, and we'll have to wait and see until the next dispute arises and see if the courts will adjudicate this in a much more timely fashion then.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.